This year's goal is to collect more than 100,000 signatures nationwide. The goal of how it's going to be now is 400 signatures. Please stop by again tomorrow night. And finally, anyone who is scheduled to have detention today, Mr. Dixon, what it will be. Have a great afternoon.
Well, the only thing is it's next to D. Okay. It's always right under. Okay. So she theoretically allowed, but it is an issue. There are a whole series of things that we hope to have upgraded when we move into a new building. Yes, and that would be communication be one of them. All right, welcome everyone. We'd like to welcome our guest panel. We're going to today, as we talked about yesterday, walk through a hypothetical scenario involving teenagers and the police, out of which charges arise, because that's what makes it interesting for, that's what makes it a court case for us. And so what we're doing today is a mock motion to suppress hearing. As they were educating me about earlier, this is going to have to be a partial one. A full motion to suppress hearing on a case like this would go longer than we have time for. And we also, of course, want to give you time to ask questions along the way as well. So with that in mind, let me introduce Judge Rufo, Superior Court Judge in Barnstable and Plymouth Counties, who has been coming here for 4 or 5 years. This is our fourth year? Fourth year of this panel. And then actually we have two new people to the panel. Assistant District Attorney Matt Kelly, who is Harwich High graduate, class of 1998, happened to be my very first year here at Harwich. And Attorney Rob Hoffman, a defense attorney who happens, by the way, how many years have you sat in the Barnstable Court?
3 in Barnstable.
Three in Barnstable. And who is Ms. Hoffman's husband, which is great. So we have new attorney, new ADA compared to our panels in the past. We have Officer Davis here, who is going to give the expertise about what happened in our scenario. And so without further ado, I will introduce, let Judge Rufo introduce what we're going to do today. Let me make sure we're recording.
As Mr. Dixon said, I'm Judge Rufo. I live here in Harwich, and I'm happy to come here each and every year that I've been able to the last 4 years. Because it's my hometown, it's my community, and as well, it's important for us to get out from behind our desks and our respective roles in the court to come out to the community and to expose you to a little bit of what we do in the court system around this issue of constitutional rights as well as corresponding responsibilities. So we all know we have rights, we also have responsibilities that go along with those rights. And what this scenario is intending to depict is a challenge to evidence that was seized during a sort of routine encounter that the police have here in Harwich involving a scenario that we're going to show. And what happens, of course, is that folks that get arrested, defense attorneys get involved, prosecutors get involved, they share information back and forth because there's reciprocal discovery. And then if they think that there's a notion that they possibly could get some of the evidence suppressed, meaning a judge could then possibly rule that the evidence is not admissible, then this thing called a motion to suppress is filed in the court, and we schedule an evidentiary hearing where the prosecutor calls witnesses in support of the government's position, that being that the evidence was not seized in violation of the Constitution. And we're talking here about the Fourth Amendment for the most part. The right of the people to be free from unreasonable searches and seizures, because that's what's at issue. And there's a whole bunch of cases that have come down from the Supreme Court, from our local Supreme Judicial Court here in Massachusetts, our appeals court, where judges like me look for guidance from those reported decisions to determine the validity of the search and the seizure of the evidence. So Matt Kelly is going to examine Officer Jeff Davis just to get out the scenario and the facts. I'm going to take some notes. Attorney Hoffman may object to some of the questions, because part of this too, the whole evidence, evidentiary hearing that we're about to show you, is that there are rules of engagement the attorneys are permitted to employ with respect to the way in which they ask questions. So ADA Kelly, Assistant District Attorney, so we've gotten it to ADA Kelly, and that's what I call him. Both these men appear before me in court regularly. They're both fine attorneys, and they've developed a real a strong knowledge of the criminal law, criminal procedure, and evidence, which they're required to have, of course, to practice in our courts, especially in the Superior Court. So this is more in the notion of probably a district court scenario, but we're playing in Superior Court right now. And so the police officer would be called, he'd be sworn to tell the truth, and ADA Kelly has some questions for him.
Thank you, Your Honor.
Hey, Matt, if you can hold 1 second. We got a bunch of students walking. I don't want them to interrupt you.
That's all right.
Guys,
Should see
come
district
in,
court.
come in real quick.
I know once you get going, you know.
Don't hurry, guys.
You know.
Take your time.
Yeah. So guys, come in. Their seats.
Listen carefully
Find
to
a
the
seat.
questioning, and then think of some questions you want to ask us after we get through showing you this little give and take with respect to the evidentiary hearing.
The scenario is designed so that you could argue either way. So you really have to think about what was done, what the police did versus what the kids did in the situation that they were in. Okay, so it's not a cut and dry that yes, they're right and they're wrong.
All right. Thank you. Go ahead, Matt.
May I inquire, Your Honor?
May.
Sir, in a loud, clear voice, can you please state your name and spell your last name for the court?
Officer Jeffrey Davis, DAVIS,
And sir, how are you currently employed?
employed by the Harwich Police Department,
And what is your capacity with the Harwich PD?
a patrol officer.
Sir, turning your attention to the early morning hours of March 1st of 2011, did you have an occasion to be working at that evening, that morning?
I did.
And at some point, sir, did you receive a dispatch around 12:30 that morning?
Yes.
And what was the nature of that dispatch?
It was a report of a noise complaint
And what specific area did it point you to?
on Main Street.
And the nature of that call, do you know who called the police?
I do not. Or does it say that it's a neighbor?
It doesn't.
Neighbor.
I'm gonna
A
try to
neighbor.
add a little bit with a
Okay.
name to help my
Okay.
case, but,
Mrs. Jones.
okay, and where does Miss Jones live?
Mrs. Jones lives at 93 Main Street.
And what did she relate to dispatch at that point?
That
Objection. Well, sustained, it's hearsay.
Well, for the purposes of the motion, but, okay. As a result of the dispatch call, officer, what did you do?
we responded to the area of 93 Main Street, shut down in the area, and heard loud music, yelling and screaming from approximately 200 yards away.
Okay, so if you could describe that area of 93 Main Street upon your arrival, what it looked like from the street.
A small parking lot.
Okay, and when you say a parking lot, was it?
There
Go
were-
ahead.
There were cars parked all over the street, all in different directions.
Okay, so just so we're clear, the court's clear, it's not an actual parking lot.
No, it's a residential street.
Okay, and your description is it looks like a parking lot.
Correct.
And how far away, and what exactly did you hear, officer?
Loud voices, loud music,
And how many cars would you say approximately were outside that residential area?
around 20.
And what did you do next, sir?
Due to the fact of the number of cars that were there, I waited for several other officers to arrive, and then we approached the house.
Okay. And upon your approach to the house, did you note anything significant about the cars themselves?
Working in my capacity as a patrol officer, I work largely with the schools. In that capacity, I did notice and realize that a lot of the vehicles were familiar to me, belonging to minors.
Okay. And when you say minors, sir, just for the purposes of evidence, you're saying for kids that are in high school?
High school kids.
And what
correct.
range would you put those people in?
Between the ages of 17 to 19.
Okay. And sir, you said that you you had heard some, you observed the cars and you heard some noise. What did you do next?
When we approached the house.
Okay. And how was that done? Was it just you?
It was myself and two other officers.
Okay. And explain, if you could, to the court what you did upon arrival at the front of the house.
Two of us went to the front. Another officer went around to the back. We approached the house. We knocked on the door, trying to get someone to come and answer.
Okay. And you had mentioned previously noises coming from the house. Did you continue to note that as you approached the house?
Yes.
And how would you describe the noise as you got closer to the house?
Very loud.
Okay. And approximately, you're on the front lawn at this point. Is that fair to
Correct.
say? Okay. What did you do next?
We knocked on the door in hopes to get somebody to come.
And what happened?
No one would come to the door, and all the music and yelling stopped.
And were you able to make any observations, Officer Davis, of the interior of the home from where you were standing? If you remember.
I don't recall.
Okay. So you testified now that you went up to the door, you knocked on the door, the music stopped and no one answered. What did you do next?
We entered the house to do a check to make sure everybody was okay, knowing the fact that they were minors. Inside, we found about 20 kids sitting around both upstairs and downstairs.
Okay. And let me just back you up for a second, officer. You testified that you entered the home. Can you describe the process of how that happened?
We turned the doorknob and went in.
Okay. Fair enough. And describe what you saw as you entered the home.
We saw many teenage kids, apparently, or in our opinion, under the influence of alcohol.
Well, specifically, how would you describe some of the kids that you saw?
Sluggish, glassy-eyed, belligerent.
Okay. Did you notice any alcohol? You mentioned possible under the influence of alcohol. Did you notice any alcohol in your plain sight as you walked in?
No, we did not.
Okay. And I'm just going to back you up 1 second, officer. It's my mistake. How long would you say you stayed at the door, knocking and calling out to the people inside prior to making entry?
Approximately 2 to 3 minutes.
And how would you describe the level of notification, let's just say, in a police officer's voice?
Very loud, very clear,
And how would you describe the way and the manner in which you knocked on that door?
very loud.
And you said that when you went in, you made these observations of individuals, as you described them, under the influence of alcohol. What did you do next, sir?
We asked them all to come into the living room so we could speak with them. Are we going with a couple of them ran? Can't remember whether we,
Yeah, I think a couple ran.
okay.
Okay.
A couple decided they didn't want to talk to us, so they took off. In bringing everybody in, knowing that they were underage, we were going to make arrangements to get them home.
Okay. And fair to say, Officer Davis, that you're the school resource officer for Harwich?
Yes,
And it's part of your day-to-day duties. It's fair to say that you interact with students at the high school.
yes,
You're familiar with faces and names.
correct.
And in your experience as the resource officer at Harwich High School, fair to say that many of the people that were in this home were familiar to you,
Correct,
and familiar to you as people that weren't of, let's just say, legal drinking age.
yes.
And when you said at that point, sir, that you arranged several of them to be driven home, what happened next?
With the other officers there, we did a quick search of the house to make sure there wasn't anybody hiding in any closets, do a protective sweep. In doing so, we located, we did locate some drug paraphernalia as well as some alcohol.
Okay, let's take that step by step. You said that you did a quick search of the home. If you could just describe briefly to the court how the interior of the home was set up.
It was a 2-story house. The kitchen, living room, and dining room were downstairs. The bedrooms were located upstairs.
Okay, and when you said, you described this sweep, fair to say that you searched all, or went through all the rooms of the house?
Correct.
And you described specifically, I believe your phrase was drug paraphernalia. Is that the phrase you used?
Yes.
And what exactly did you find, sir?
2 marijuana pipes and a marijuana bowl.
Okay, and where were those found, sir?
They were located in the upstairs bedroom.
Okay, and in that bedroom, sir, well, describe the process of how they were discovered in that bedroom, if you could.
We went upstairs, announced ourselves as police officers, asked anyone in the room to come out, show themselves. They did not. We entered the room, located in an open drawer. We found the drug paraphernalia.
Okay, and when you say in an open drawer, sir, did you have to manipulate any clothes or anything to see this paraphernalia?
No, sir, the drawer was open.
And in your training experience, this was immediately identifiable to you as contraband?
Correct.
And you had also mentioned in the seizure, in your search, that you recovered some alcohol, sir. Is that fair to say?
Yes.
Specifically, if you remember, officer, where did you recover the alcohol?
The alcohol was in an upstairs bedroom to the right.
Okay, and if you could just again describe the process of sort of the seizing, if you will, of this alcohol.
Very similar to that of the marijuana. We went upstairs, announced ourselves, went into that bedroom, and in plain view, there were 2 30-packs of Budweiser.
Okay. At some point, sir, did you have a conversation with the person who was in control of this house, let's just say?
Yes.
And you remember that person's name? ago?
Jim Jones,
Okay. And how old was that person, sir?
18.
And was that person asked about what was discovered in the house?
He was.
And what was his answer to that?
He didn't know how it got there.
Okay. And you mentioned that there was 20 people in the house. Well, what eventually happened to everybody?
Everybody was arrested for minor possession of alcohol.
Okay. And I have no further questions, John.
All right. Attorney Hoffman, cross-examination.
Thank you, Your Honor. Good afternoon, officer. You responded to a report of a loud party at the house.
We did.
You saw all the cars in the driveway,
We did.
and you were there because of violation of the noise ordinance, right?
Correct.
And you had a couple of other officers with you, right?
Correct.
You went up to the front door, is that right?
Correct.
One of the officers, you said, went around the back of the house, right?
Correct.
And the purpose of that is to secure the house, isn't it?
That's correct.
You knocked on the door, right?
Yes.
And at that point, the house became quiet, right?
Yes.
At that point, there was no longer an issue with the noise ordinance, isn't that right?
Correct.
When nobody came to the door, you testified that you turned the doorknob and went into the house, is that right?
That's correct.
You turned the doorknob and you opened the door first, right? Is that right? You opened the door first?
Correct.
And at that point, you could see into the house, right?
Correct.
And could you see anybody in that area at that point?
There were a few people in the living room, yes.
Okay. You didn't ask any of those people to come and speak to you, did you?
At that point, no.
No, you went right into the house.
Correct.
When you went into the house, did that put you in the living room of the house?
Yes.
Now, you mentioned that you saw some drunk people there, is that right?
Correct.
And you described them as sluggish, glassy-eyed, and belligerent, right?
Correct.
You didn't see anybody unconscious, did you?
No.
You didn't see anybody throwing up, did you?
No.
And at that point, you asked the people there to have everybody come into the living room, isn't that right?
Correct.
And everybody did come into the living room, isn't that right?
I don't know that everyone did at that point.
You did a quick look around the house, right?
Correct.
And there was nobody else there?
No.
You mentioned that a couple of kids ran away, is that right?
Yes.
And at that point, one of the officers moved and stood in front of the doorway that those two kids left out of, didn't they?
I'd object to that. It wasn't a topic of direct, so I'll have to sustain the objection. It's not a fact in evidence.
Well, it could be now.
Well, if you have a foundation.
An offer of proof, Judge, in
All
the
right.
report,
I'll
there's
take
an
an offer
indication
of proof.
that the officer, one of the officers blocked that.
Fair enough, you can inquire.
Thank you, Judge. One of the officers stood in front of the back door at that point, right?
Correct.
To prevent anybody else from leaving?
Correct.
And the initial search of the house, that's done to make sure that there's nobody that's in trouble in the house, nobody in danger, isn't that right?
That's correct.
And that's done by, as you testified earlier, you announce, right, that I'm a police officer, I'm out here, is there anybody in there, is that right?
Correct.
And then you look into the room to make sure there's nobody in there.
Correct.
And you checked the first floor and you didn't find anybody in any trouble, right?
Correct.
Nobody's expressing any concern for any other individuals that might be in the house, right?
No, sir.
And then you proceed to the upstairs of the house, right?
Correct.
When you get upstairs, there's a couple of bedrooms up there, right?
Yes.
And when you go into one of them, you announce that you're the police, nobody comes out, right?
Correct.
So you peek in there and you don't see anybody,
Correct.
right? But you said you testified earlier, you saw some marijuana paraphernalia in a drawer, is that right?
Correct.
And at that point, your concern is there anybody in trouble in here, right?
And for my safety, to make sure there's no one up there, they shouldn't be. Correct.
Well, right, but it's people you're looking for.
Correct.
And you certainly weren't concerned that there was somebody hiding in that drawer, right?
Not in the drawer, no.
Okay. Stop there.
All right. Anything on redirect 88, Kelly?
No, thank you.
All right. Then we'll stop right there. All right, what's going on is that we have the facts now that would come out, and of course, many more facts would come out if we had the full hour and a half that it would take to flush out all the facts in this particular case. And there might be more than one police officer called too by the Commonwealth to flush out more facts based on what the Commonwealth feels they have to get in terms of meeting the criteria to ensure that there was no violation of the Fourth Amendment with respect to how this evidence might have been seized as a result of this scenario. So what I'm asked to do is to listen to the evidence, judge the credibility of the witness, who I find to be credible. He's also under the threat of criminal prosecution himself if he ever lied on the witness stand, so we take that into consideration. Plus, there's a special statute of law that says a police officer, by signing his or her name on a police report, is susceptible to arrest and criminal prosecution if they falsify information. So that goes a long way too in terms of helping us make a determination as to what happened. So, and we do find that by and large the police officers are very truthful, even if some of the facts, quote, hurt them with respect to this scenario as to whether or not it fits within the framework of accepted police procedure vis-a-vis the constitutional law. So what I have to do is, I'm going to listen to the attorneys argue in a moment because we have some time for that. So I'll hear their argument about why the evidence should either be suppressed or not be suppressed. And ADA Kelly will go first. And then I have to look up case law from both the Supreme Court of the United States, our local Supreme Judicial Court here in Massachusetts, and the Appeals Court, and then try to find whether or not the case law will give me some persuasive authority to make a determination on whether or not the evidence, some or all of it, should be, quote, suppressed. So what we have really is a tug of war between our rights and our responsibilities, because we all have the right to have a good time, to do so within the confines of our own home. And anytime the police come near a home, that's considered sacred ground. And we start with the basic premise that no person in their homes should be subjected to an unreasonable search and seizure of their home. But then we have a situation involving the police having this community caretaking function for all of us to ensure that we're safe, not only out in the open, out in the street, at White House Field, in the parking lot, but also in our own homes. Because sometimes they get phone calls from anonymous callers, or now with caller ID, they pretty much know who calls. That's how you know it's Mrs. Jones from next door. Call dispatch, and that information is transmitted to the police via their police radio, and that's how they're dispatched to the scene. So we have a basis of knowledge as to why the police were there in the first instance, and that is a possible violation of the Harwich noise ordinance, which places them there. And then we also have the situation of possible public safety concerns about the, quote, parking lot, you know, whether a fire apparatus could fit down the street if it ever had to, or whether cars can safely pass, given the amount of cars that Officer Davis described in the scenario. So I'm not going to give too much more of it away. So what are you trying to get out here, ADA Kelly? No.
Okay. The key to the I didn't know if you actually wanted to argue. The key to the analysis, hi everybody. Like I said, my name is Matt Kelly. I'm an assistant DA. What I have to do is justify the search, and as the judge just alluded to, you know, there are going to be several issues that I start with, but the primary issue for a prosecutor in this situation is trying to argue a reason why a police officer could go into your home. Like you said, the home is your castle. Now, the first thing I want to know is whether or not there's a search warrant. Because if there's a search warrant, it's really a whole different, whole different game, whole different analysis. We'd be looking at the warrant itself rather than the officer's actions that particular night. Obviously, in this case, there wasn't a search warrant. So now I need to start dealing with reasons why an officer could get into your home without a search warrant. So, if I was making a closing argument, so to speak, on this motion, I would try to organize my thoughts in such a way as, first, how did he get there? How did he get there? Why is the officer standing where he's standing to hear this noise ordinance? So, it's important that we introduce a caller, a civilian caller, somebody that's from the community that's concerned about what's going on in the house and what's going on in the street. It's important that I get the name of that person because, it changes it. What if I had an axe to grind with somebody and I said, hey, you know what, police, I think there's a party going on over on South Street in Harwich. So now you get a named person, a concerned citizen who doesn't necessarily have an axe to grind and has put themselves at risk one day of having to come in and testify about what she heard. So we get that name, and then the next step is, okay, now the officers are there. How did they hear what they heard, and how did they see what they say they saw? Obviously, Officer Davis testified that the noise was very loud. He actually used great language as a police officer to the point where I had to ask another question about it, that there were so many cars, it was like a parking lot in front of the home. He described it as a residential area. You know, and then my next argument to the judge is, what do we expect our officers to do at that point? Well, there's a noise ordinance violation. He goes up to the front door, and he's got to try to get rid of this situation. So what does he do? He doesn't kick down the door when he gets there. He said he waited several minutes, knocked, yelled, saw these minor cars. So what do we expect our officers to do at that point? Walk away? Say, you know what? They got me. You know, I'm not gonna look any further into this. No, because what happens if, you know, a week from now down the road, somebody was passed out and ends up getting in trouble in that home? You know, my argument to the judge at this point is, you know, as a community, he has a member of the community, the police have a caretaking function. They need to make sure they know what's going on in that house. They need to be able to defuse a potentially, you know, dangerous situation. So the next step, he didn't use a battering ram. Nobody went in through a window. They opened the door and they announced again. At that point, they saw several young people, as he described it. He had a very good basis of knowledge to know that these people were under 21, and in his training and experience, found them to be intoxicated. You know, we moved up to a situation where the officer has to deal with it. Clearly, you can't walk away from a room full of 17-year-olds who are drunk and not at their house with a parking lot outside. So now the next step of the analysis is, what do we do? Does he just have to say, you know what, you 5 people in this living room, that's it, we're leaving, see you later, and lock the door behind him? No, my next argument to the judge is, all he did next was kind of walk through the house. He didn't kick down doors, you didn't hear any evidence of anything, drawers being opened or safes being searched. He just went through and made sure that everybody that was out of that house, and in doing so, in plain view, and that's important, it was just in his plain view. So my argument is, hey, he wasn't looking for drugs. He wasn't looking for alcohol. He was looking to get people out of that house. So that's essentially would be my argument in that case, is that it was a logical, it was very step by step, it was very logical. There was no overstepping of the police's bounds. No, Rob will tell you why. I'm wrong. Potentially.
This is kind of a tricky situation. What I would try to explain to the judge, and I would try to persuade the court to see it my way, is that maybe the police didn't really do anything particularly wrong here in their search for safety for these kids, but whether or not they did something wrong on a constitutional level, and whether or not anything should be able to be used in court against these individuals. Because, as Mr. Kelly said, the home is your castle, and the whole idea that I would be stressing in my argument would be that we have to protect the sanctity of our homes, that the police cannot come into our homes. And I would phrase it in my argument in such a way that the police responded to the house appropriately, they knocked on the door appropriately, everything they did was appropriate until the minute that they opened that door and stepped through that threshold without an invitation. Because once that door was open and they have contact with people, they could have asked for an invitation, in which case probably this motion would have been over. If somebody had said, come on in, as long as that person had the authority, but that's a different conversation. But if they were invited in, that would change everything. But they saw nothing until they all went into the house and invaded, I would say, the sanctity of this home, and thereby violated constitutional rights of the owners and occupants of that home. But then the issue becomes, what happens once they see the alcohol, or once they see the people that are impaired? Now, my job as a defense lawyer is not to criticize the intentions of the police. It's the actual outcome of where the evidence comes from, how the evidence comes in front of the court, and whether or not it should be able to be used against certain individuals. So that's why I was asking certain questions of the police. Like, one of the questions that didn't come out as smoothly as I think it normally would is, why are they blocking the door and preventing people from leaving? Now, if anybody makes any statements, and this didn't come up in this, one of the issues will be, were these people free to walk away from the police, or were they in police custody? Were they being restrained? That's why I was asking that question. But some of the other questions I asked is, why a protective sweep in these circumstances? Now, the police, the Officer Davis had said that it was his concern that there might be somebody in trouble in this house because of alcohol. And then the court has to consider whether that really is the concern, or whether that's partially the concern, or, you know, what's really going on here. And while it is a legitimate concern to look for people that may be in trouble, the court has to consider whether the actual search that took place fits with the concern that the police have. And that's why I was asking the questions about the drawer. And you ask if there's anybody in there, you look in, nobody's in there, you kind of move along. And in this particular situation, I think it's unlikely. A protective sweep, in case anybody doesn't know, is to really locate other people that may be in the house. It originally kind of came about for when officers are going to actually do an investigation or conduct interviews or perform a further search of a house, and they sweep the house to make sure there's nobody in there that could do them harm while they're trying to do their jobs. In a situation like this, where it's the community caretaking type situation, it's similar. They're looking around to make sure nobody's in trouble. But it doesn't take a lot to find out that nobody's in trouble. You don't usually have to look into bureau drawers. I'm not exactly sure about the 30-pack of alcohol. That's a larger item. I'm pretty sure that could have been in plain view, in which case that would have been trouble. And if they find the alcohol, that changes everything. My argument to the court is, fine, you've got some alcohol here, but the minute they walked in the door without an invitation, the police crossed over the line. They made sure nobody was in trouble, but any evidence they found is still found in violation of a person's constitutional rights and shouldn't be allowed in court. Anything that they find, they can confiscate. That's the way that works, but they shouldn't be able to use it in court against an individual.
So here's where we are. The case is not coming for trial yet. This is a pre-trial motion. And as the case is developed in court, the Commonwealth comes into possession of certain information. He's duty-bound to share everything that he knows about the case with the defense. So it's wide open. Discovery's wide open. It's very transparent. And as the prosecutor finds out from the police officers themselves and the police report, and then even viewing the documentary evidence, sometimes they even go to the scene to view the scene themselves to get ready for these motions to suppress hearings, because sometimes it turns on vantage point in terms of how the officers could have seen what they say they saw at that particular point in time. All of that prep work goes into these motions. Then we're asked to look at the case law. And there's many issues here with respect to whether or not the police could do what they did, which is to actually turn the knob and enter the home. Of course, the question I'm sure some of you have in your mind is, what would happen if the door was locked? Let me ask the officer, I'm going to put him right on the spot. What would happen if the door was locked? What would you do?
We would probably try to contact the homeowner.
You wouldn't just leave and go back to the station?
No.
Right.
And try to get permission to enter the home that way.
All right. And what if nobody gave you permission to enter the home? The homeowner, you looked them up on your police database, and you've got the homeowner's telephone number. And what if you couldn't get in?
Well, we have a detective unit, and they could come down. We would probably wait a little bit to see, and we would try to coax them to try to get somebody to come to the door to try to open it.
And what's the reason why you're trying to get someone to allow you to open the door?
Given the fact that, I would argue that given the fact that when we arrived, there was lots of voices, lots of music, lots of noise, lots of banter, lots of things going on, and then when we approached the house, all of a sudden everybody became quiet. We would just want to make sure that everybody was okay.
Well, you're performing your community caretaking
Correct.
function. You're not just going to walk away because you can't get in. So there's many scenarios here, but there's a great case. It's called Commonwealth versus Albert Lewin. It's a Boston case. I happen to know it because I originally am from Boston. And the Lewin case talks about this whole idea of protective sweeps. And protective sweeps are, once the police are able to be in a lawful position inside someone's home, sometimes in the Lewin case is pursuant to a search warrant. And a search warrant sort of gives the police some protection, and the Commonwealth too, because a neutral and detached person, a judge or a clerk after hours, can actually issue a search warrant based upon probable cause, where the police under oath, right, you sign an affidavit indicating what you know, and based on what the police know about a situation, it's usually involving a drug investigation, not just a house party with noise, but it could. And the search warrant allows the length and breadth of the police intrusion. And as I was listening to Attorney Hoffman argue, I remembered that the statute out in front of the Barnstable Superior Court is really where this all began. His name is James Otis. Have you heard of James Otis? And has Mr. Dixon talked about him?
Mr. Houston should have taught you.
Huh?
Mr. Houston probably taught you.
Yeah, the history teacher, I'm sure. James
So everyone
Otis.
nod their head and say yes.
Yes. James Otis and his sister, Mercy Otis Warren, are depicted by statue in front of the court. They're standing out in front of the court. in bronze. And the reason why is because they were both born in West Barnstable, right near the Barnstable Superior Court on Route 6A in Barnstable Village. And the two of them were educated, and they wrote provisions that made its way into the hands of John Adams, guaranteeing the prohibition against the writs of assistance, they were called. That was the old-fashioned way that the king used to check on people who were the colonists to see if they had any contraband, i.e. items in their house that they hadn't taxed yet. And what would happen is members of the British troops would show up, this is the Boston Massacre, and they'd kick the door in. None of this turned the lock business. They would take the battering ram back then, kick the doors in, and go into the colonists' homes to search. And the colonists had enough of this, and they said, we don't like these writs of assistance, that's what they were called. The soldier would just write out a writ of assistance, they go in, they take out anything that they thought was evidence, and then they would prosecute the colonists for not paying their taxes. So James Otis railed against the British Crown and said, we need something called the Fourth Amendment, which says no searches and seizures. They have to be based upon probable cause, they have to be based on reasonableness, et cetera, et cetera, et cetera. So that's where this all started. So what do we have? We have a community caretaking function. We have this other thing called the Plain View Doctrine. What's the Plain View Doctrine, ADA, Kelly? Let me get you back in.
Okay.
Stand up and address the class.
It's like I'm back in school.
He's a Harwich High grad.
If the officers are legally somewhere, whether at the side of your car or legally in your house, and they see something in their plain view, whether be by flashlight or be by sight, that is immediately identifiable to them as something that is illegal, bag of weed, in a case of 17-year-old kid's a 30-pack of beer, then he can seize it, and that would stand up against scrutiny ultimately.
Right. So the protective sweep, of course, is to look for persons in trouble. Attorney Hoffman made that point. And of course, we're wondering, and I'm concerned as to why Officer Davis or one of his fellow officers is looking in someone's drawer that might have been cracked open to see if they can find something else. That wasn't the original purpose of the protective sweep. So there are limits in bounds as far as how far the police officers can go. The point made, which wasn't a scenario, so I apologize, about blocking the door all goes to the issue of voluntariness of speech, because we all know about the Miranda warnings that we're all entitled to, and that's not part of the scenario, but it could possibly develop there, where the police can ask certain questions. They have the right to ask people's names, rank and serial number. That's called a field interrogation and observation. They have the right to ask you your name. If you don't give them your name, that's possibly an arrestable offense for failure to identify, or if you give a false name, that's also an offense. But we're not here for purposes of the trial. That's going to come later. This is just a motion to challenge, if you will, the sufficiency of the evidence that was seized, possibly in violation of the Fourth Amendment to the Constitution. Later on, ADA Kelly has the burden of proof in a criminal case, which is to prove the elements of any offense beyond a reasonable doubt. You know that. That usually happens in front of a jury, or it can happen jury-waived in front of a judge, where I have to make that call based on a high standard of proof as to whether or not the elements of the offense are existing so as to warrant a conviction where someone could suffer incarceration, being sentenced to a jail, house of correction, or a state prison sentence. And the Commonwealth is operating on the assumption that the defense has, which is that everybody's entitled to the presumption of innocence. You can't be found guilty unless a jury or a judge finds you guilty beyond a reasonable doubt. We're not there yet. We're only at the pretrial stage in the so-called motion to suppress the evidence. So let's open it up to questions and discussion. Who's got some questions and discussion about it? Amy, you gotta go first. You've been listening all along. I'll put you right on the spot because your father told me to. I will give Amy a break for a second.
Thanks, Dad.
Who's got a question or a comment about this?
No.
Mike.
Can you imagine being in that scenario and what we...
He's got a question right here, Mr. Dixon.
Isn't it if anybody makes a
You
noise?
gotta speak up so we can hear you.
If anybody inside the house makes a noise, isn't that consent to go inside?
Well, not necessarily, because the noise ordinance, how many decibels in our Harwich noise ordinance?
Wait, from a person.
Oh, anything that can be heard at 150 feet from the property line.
So they have some measuring stick. I didn't know what it was myself.
Yeah.
I'll have to keep it down on South Street. That's where I live. But if the police feel that there's a violation of the noise ordinance, that gives them the right to be there. Because, everybody has outdoor barbecues in the summer, and adults get loud too. Do adults ever get loud in Harwich?
Oh, yeah.
So,
Really, what gives them consent to go inside
sorry?
the house? What gives them consent to go inside the
well, in
house?
this case, no one was outside. So They know there's a lot of people around because Officer Davis recognized the cars as belonging to some of you, minors. So he can use his knowledge. Okay, that's information that he can use to decide whether or not someone might be at risk in the house, i.e. under the influence. And if he walked away from the situation, he could get in trouble with not only his superiors, but the town officials, because if someone got sick, injured, or died as a result of ingesting too much alcohol, let's stay with that for a minute, the town would be susceptible to a civil suit come before me seeking, hundreds and thousands of dollars or more, millions, for the value of a young life that was lost because they didn't perform their community caretaking function. So he has that in the back of his mind too. That's part of what he's there to serve and protect. He's there to protect all of us from our own selves, if you will, in case of someone possibly overindulging in alcohol. Who had a question over here? Yes.
Can you not enter a home without
You have to speak up, honey. I can't hear you.
Can you not enter a home without a warrant?
Well, yes. We start with the premise that you need a search warrant, but because of the situation, they don't have time. They're not going to walk up to the house and say, "Hello in there, we'll be back in about 3 hours after we find the judge," or the clerk, and get a search warrant. So it's not practical all the time to get a search warrant. Now, if there's an ongoing drug investigation, we don't have any of those in Harwich, do we? I told you, I live in Harwich, so I'm getting concerned. I'm just doing my due diligence here. But if there was an ongoing drug investigation in Chatham,
Good.
Yeah.
then the police would be under surveillance, and they're watching things that are going on. They have time now to develop information, and they don't want to pounce before they can get the stash, just like you see on Law and Order and any of those crime shows, which I do not watch at night. But that's where they have enough information to put into a search warrant, go before a judge, and now they can enter with the protection of a search warrant. Good question. Who else had a question? Yes.
I just don't understand how they get a call about noise,
Yeah.
but then it's all of a sudden this assumption that everyone's I feel like it's really started. I know it happens, whatever, but I'm serious.
Well, put it this way. If they walked away and there was drinking going on, and then someone left the party and smashed into a tree and was killed, it's sort of a little bit too late to say, well, maybe they jumped the gun. It's better for them to perform their community caretaking function. The law recognizes this. And to investigate without intruding on your rights, without going overboard, understanding that a person's home is in fact their castle, and we prefer that they have a search warrant, we prefer they have probable cause, but we want them to be protective, because I think this happens every now and then. Parents leave their home and say to the kids, "We're going up to Aunt Bessie's house for the weekend in Vermont, and I know you're not going to have any kids over, right?" And you say, "Absolutely, positively, you can trust me, all the way to C Street." Next thing you know, it gets posted up on Facebook. Mom and Dad are away, party at his house. What's his name? And 22 cars, and 22 cars show up on the street.
But to your point, though, the entry itself, at least I would argue as a prosecutor, alcohol hadn't been introduced into the situation yet. You can community caretake for various reasons. You keep in mind, I would focus on that portion of the argument, how loud it was, how many cars there were, and the fact that as Officer Davis approached, all of a sudden he knocks on the door and it goes quiet.
So
It's a little suspicious, right? And that doesn't necessarily have anything to do with alcohol. It only becomes an alcohol issue when he needs to do the sweep when he goes into the house. And that introduces the other arguments of, well, these are young kids, and now there's all this alcohol present. 17 of them look drunk. I probably need to go look upstairs to make sure somebody that's not that experienced with alcohol isn't throwing up in a bathroom and going to be in trouble in 3 hours when I kick everybody else out of the house.
Keep in mind that when we talk about standards of evidence, to get a conviction at trial is proof beyond a reasonable doubt. But to get a warrant or to justify entry is not proof beyond a reasonable doubt. It's probable cause, or in some scenarios it might be reasonable suspicion on certain scenarios. So you can't say, well, they can't prove we had alcohol. That's just a stereotype. Well, it's true, but they don't need to prove it. They need to have reasonable suspicion in some circumstances, probable causes in others.
if they're like are a bunch of cars, but there's no noise complaint, but a cop is like, oh, there's a bunch of cars, so they go, can they have any reason to go
No,
in the
well, you
house?
just changed the facts, which illustrates a good point. It illustrates a good point. Each and every fact pattern has its own uniqueness. That's why there's no cookie cutter that I can pull out of my drawer and say, this situation is this. Sometimes it's close, but it's never the same. So that little change in the facts here would probably say, absolutely no way could they go any further. Although, another part of community caretaking function, I think I alluded to it, is he described the area as a parking lot, so that the call could have come in from the next door neighbor saying, I'm concerned, I have an elderly parent living here, I'm afraid that, she's short-winded, I might be calling for an ambulance, and an ambulance can't get down the street because the street's blocked, because the kids are parked on both sides of the street, or whoever is parked on both sides of the street, clogging, or a fire apparatus, the engine 69 from the Harwich Fire Department can't get down the street because it's a big truck.
So could the cop just go and just be like, move your cars to
Sure.
the room, or do
Yeah, they
have to be
can.
like,
So they
oh, you
walk
have to leave?
No, that's right, no, they can say, please move your cars, and someone opens the door, and then ba-boom, they smell marijuana.
What if there's no smell, no alcohol, nothing?
Well, in that case, I was just
Given that case, we would be driving by, we would go up to you, we would knock, you would answer the door, assuming you would come to the door, we would tell you what our issue was, we had a parking complaint, or we're afraid a rescue or a fire truck or somebody can't get through, could you have the owner of that vehicle move it so that
So
we
the
can get
cops
through?
have like no right to just ask them, like everyone to leave the house?
Well, it depends. If they don't see anything that is possible illegal activity, no, they really cannot, and I don't think they would in that situation. Yeah, if they're concerned about the possibility of illegal activity going on, they have the right to continue on with their investigation within the bounds of the Fourth Amendment.
Thank you.
I can't say yes or no. I mean, I just can't, because it all depends on the. This is what we call the iterative approach. It's little building blocks of knowledge that make it all the way up to reasonable and articulable suspicion or probable cause, and that's what the police are entrusted to. They're trained. They have certain responsibilities by statute, by law, and they are our community caretakers. They're there to help us make it through, and be safe.
We have 2 minutes.
Okay, someone had a question.
Well, I
Yeah.
want to make sure you have time to issue your decision.
I think those are proper entry made, that the motion to suppress would be denied respectfully, and that the evidence could come in later at criminal trial. Who else had a question? Someone, I think, someone over here.
I have a question.
Yes.
So say that someone has a party and that half the kids know there's alcohol there and they are upstairs drinking, and the other half choose not to and decide to be in the basement the whole time. Are they excluded from being charged with possession?
He loves these two words, joint enterprise, okay? They want to get everybody saying that if you are somewhat complacent, if you are somewhat participatory, and the level of participation will determine, then you're engaging in a joint enterprise of criminal activity, that you can be just as guilty as the person. The classic example that we learn in law school is, I'm only going to be the getaway driver, and I told them, when you go into the bank, don't bring a gun and don't shoot the teller. Guess what? The guy goes in, shoots the teller. The guy driving the car said, I really didn't want to participate in that. I didn't want to, You're now guilty as the original perpetrator. It's called the joint enterprise theory. So I can't say for sure that the kids who weren't drinking, who said, I'm not going to participate, aren't going to be charged, but their level of culpability will be assessed by the district attorney in terms of how they're going to pursue all the occupants of the house. We're out of time. Thank you for listening. And
All right, everyone, please give a round of applause to our panelists today. If everyone can do me a quick favor, take your chair, either place it over on one of those tables over there, one of the tables over here, and they also need tables set up in the middle, back where you are. So if you could help move the tables around, that'd be great. Thank you.
I do.